In an attempt to prevent the nuisance lawsuits filed by several United States cities, Congress passed the PLCAA, the Protection of Lawful Commerce in Arms Act. The Protection of Lawful Commerce in Arms Act bars certain lawsuits against manufacturers and sellers of firearms. As relevant, it provides that a qualified civil liability action may not be brought in any federal or state court. That's 15 U.S.C. 7902A. And defines the term to include a civil action or proceedings against a firearm manufacturer or seller stemming from the criminal or unlawful misuse of a firearm by a third party. That's a subsection 5A. Now, while sometimes referred to as blanket immunity for gun manufacturers, there actually are situations where suit can be filed. But the PLCAA's general bar on these suits has an exception, usually called the predicate exception, relevant here. The exception applies to lawsuits in which the defendant, manufacturer, or seller knowingly violated a state or federal statute applicable to the sale or marketing of firearms, and the violation was a proximate cause of the harm for which relief is sought. That line, knowingly violated a state or federal statute applicable to the sale or marketing of firearms, is important. Not only does the manufacturer have to violate the law, they have to know they're doing it. Furthermore, the violation must be related to the cause of the lawsuit. In fact, the PLCAA was passed specifically to stop the type of lawsuit Mexico brought to the federal courts. Here, the government of Mexico sued 7 American gun manufacturers, alleging that the companies aided and abetted unlawful gun sales that routed firearms to Mexican drug cartels. The government of Mexico claims that these gun manufacturers aided and abetted gun sales that were being sent to Mexican drug cartels. As Noel J. Francisco argued before the court,
again, no case in history supports that theory. Indeed, if Mexico is right, then every law enforcement organization in America has missed the largest criminal conspiracy in history operating right under their nose, and Budweiser is liable for every accident caused by underage drinkers, since it knows that teenagers will buy beer, drive drunk, and crash.
So what was the basis of Mexico's allegation that these companies knowingly violated state or federal law? The basic theory of its suit is that the defendants failed to exercise reasonable care to prevent trafficking of their guns into Mexico, and so are responsible for the harms arising there from the weapons misuse. It alleges that the manufacturers were willful accessories in unlawful gun sales by retail gun dealers, which in turn enabled Mexican criminals to acquire guns. And it sets out 3 kinds of allegations relating to how the manufacturers aided and abetted retailers' unlawful sales. The manufacturers allegedly supply firearms to retail dealers who they know illegally sell to Mexican gun traffickers, have failed to impose the kind of controls on their distribution network that would prevent illegal sales to Mexican traffickers, and make design and marketing decisions intended to stimulate cartel members' demand for their products. Now remember, in order for the exception clause of the PLCAA to be effective, the alleged activities must directly lead to the harm alleged. During oral arguments, Justice Thomas asked Mr. Francisco, attorney for the gun manufacturers, to list the chain of events Mexico was describing.
In your brief, you summarized the chain that you've mentioned or alluded to a number of times. Mm-hmm. Would you just list the chain for our benefit?
Sure. It starts out with a licensed manufacturer, a manufacturer that the federal government says is allowed to make firearms. It then distributes its legal firearms to licensed distributors who the federal government says are allowed to distribute them. They then sell to licensed retailers that the federal government says are allowed to retail. Those retailers, some very small percentage of them, unknown number, but some small percentage of them, transfer those firearms illegally to straw purchasers. The straw purchaser then hands it over to the actual purchaser. You then have a smuggle across an international border, yet another violation of law. The smuggler then presumably gives it to the cartels who are illegally possessing the firearm in Mexico under Mexican law, as my friends have described it. Then the Mexican cartels engage in murder and mayhem against the good people of Mexico, all of which in turn causes the Mexican government to have to spend money to respond to that murder and mayhem. With respect, there's not a single case in history that comes close to that. They don't even cite cases that find a manufacturer, I think, ever liable for the unlawful criminal misuse of its products, other than the cases that PLACA was meant to prohibit, and perhaps other than the Avis case, the Florida Supreme Court case. But they certainly don't cite anything that comes close to that chain of causation, which is more extreme than the cases that PLACA was meant to prohibit.
As you can see, the criminality does not come from the actions of the gun manufacturers or distributors, but further, most of it much further down the chain. This explains the court's opinion. Held, because Mexico's complaint does not plausibly allege that the defendant gun manufacturers aided and abetted gun dealers' unlawful sale of firearms to Mexican traffickers, the PLCAA bars the lawsuit.